the research project is also interacting with fact-finding, and the idea is that it all bringing together the relevance of discussing the global dimension of taxpayers' rights. An honest taxpayer doesn't have to be afraid of anything. However, an honest taxpayer may be stuck with the need to go before two courts and then come out to difficulties in enforcing his rights, and that is something that we're trying to sort of at least bring on the global agenda.
I think the very close cooperation of tax administrations these days, joint audits, international data transfer worldwide, automatic data exchange of big data needs to be counterbalanced by starting to think about taxpayers.
One finds that one comes back on tax matters to very basic questions of public international law, jurisdiction, nexus, issues like that. Right. And it's good to re-establish our dialogue with public international lawyers.
Thank you, Luc for participating at our conference. We're very happy about that. During your presentation, you made a point on COFL and the beneficial ownership cases that I thought was really interesting, and it also touched upon member state sovereignty. Perhaps you could just elaborate a bit on that?
Sure. Under COFL, under the merger directive, Denmark had the right, but not the obligation, to enact anti-abuse measures. And apparently no anti-abuse measure was enacted by Denmark, and then the Court of Justice said it's up for the Danish National Court to look into domestic law to see whether any domestic law rule or principle allows Denmark to counteract the abuse that was at stake in the COFL case. My understanding is that there was no such anti-abuse measure, and that the Danish court said cannot prevent the abuse. So there was a vacuum, so what I called in my presentation a vacuum. There was evidence of abuse, but Denmark was not able to stop it. Now here in these Danish beneficial ownership cases, the same occurs, but the court decides otherwise. The court now says there's a general principle that abuse of law, EU law, must always be prevented. And even if Denmark has no anti-abuse measures in domestic law, it must stop that abuse under that general principle. Right. So that's why I say that the COFL case has been overruled. Right.
And why is that a sovereignty matter as well?
Well, it's a sovereignty matter in the sense that states, when they adopt the merger directive or parent subsidiary directive or interest and royalty directive, they reserve their rights to enact anti-avoidance measures, and they may even decide not to enact anti-avoidance measures. Right. And now with this new decision that there is some general principle that forces countries to prevent abuse of directives, again, that part of the sovereignty has been taken away from them. I think legal certainty is jeopardized by the decision of the court. Of course, if the court decides in 2019 a provision which was enacted in 2003 has to be interpreted already from 2003 in the way that we just decide. I understand that type of case law, but I don't think that type of case law should apply here, because what the court has done is it has really invented a new principle, and applying a new principle with retroactive respect to transactions that occurred before that day is, in my view, a jeopardy of legal certainty.
So has COFL been overruled by the EU court?
I think that it has actually been implicitly overruled in the Danish beneficial ownership cases. I think that what is recognized in those cases is the existence of a general anti-abuse principle which applies in European law generally, and therefore removes the requirement for domestic anti-abuse legislation. You can look, for example, at a parallel development that occurred in Switzerland. A couple of years back, a case came up to the Swiss Supreme Court on the Switzerland-Denmark Treaty, which didn't have any anti-abuse principle. It didn't have beneficial ownership. And in AAPS, the Swiss Supreme Court said, we don't need that. anti-abuse of tax treaties is a general principle that applies to all treaties, regardless of whether the treaty itself contains beneficial ownership wording or not. I think we're simply saying the same development occurring in European law with regard to both primary and secondary European law. It will take a little time for it to be confirmed, but I suspect that's the way we're going.
Right.
Withholding taxes are a major problem for individuals and for businesses. They're a cash flow disadvantage. They are often higher than the tax rate that the taxpayer would otherwise suffer, and they often involve payment and then repayment there. Historically, withholding taxes were linked to what's sometimes referred to as the revenue rule, the fact that countries will not assist one another in collecting taxes. So if a payment is made across border, and I'm only concerned with withholding taxes on cross-border payments, if a tax is not withheld and it's paid to the recipient in the other country, then unless that recipient volunteers to pay the tax or they have other assets, the tax authority cannot get the money. The money is gone and they can't say to the other country, please help us to collect. Except now in Europe they can. Under the Mutual Assistance in Recovery of Duties Directive, we have almost complete cross-border assistance in collecting taxes, certainly for all direct taxes. So if a resident of France makes a gross payment to a resident of Belgium, and the Belgium recipient has a liability to France, it's perfectly feasible for the French to seek information through the directives and then to seek collection if the taxpayer doesn't voluntarily deduct. So there is really no justification any longer for withholding taxes within Europe. It is simply a matter of administrative convenience, that it's easier to have the tax withheld, but actually when you take into account the compliance burden on taxpayers and the barrier that it represents to cross-border trade and investment, you realize that withholding taxes really ought to be something that we should try to wipe out, not just within Europe, but internationally. There are some countries around the world, I don't want to particularly identify them, where pretty much any service you provide to someone in that country, when you get paid, tax is withheld. And you've then got to try to go through a process of reclaiming, which involves documentation, compliance, and often a long wait before you get the money. And for businesses, that can be absolutely critical because you lose that cash flow during that time.
At some point years ago, the EU Court of Justice said that actually withholding tax as a mechanism is a restriction, but it can be justified. But could you even foresee that at some point the Court of Justice will actually go away from that jurisprudence, saying that simply that is not a justification anymore?
I think they could easily do that, because at the time that they said that, the systems for cross-border assistance in collection were more limited, the number of taxes that were covered were more limited, and the systems were not operational to the same degree. Now that we have a much more established system for recovery, and we have computer arrangements that link tax authorities, there's every reason for the court to say the administrative advantages that we saw that justified this 15, 20 years ago, it's now changed, and it's time to reconsider this issue.